Oh, and look, he turned it on just as I
Oh,
hit record.
perfect timing, Luke. Thanks for joining us. Hey,
Sorry, I was trying to
everybody.
get situated.
I
Got my
like it. Well,
notebook
we are
over here.
already recording, Luke, so watch what you say now.
Okay.
Good evening. I'm Leslie Hawker. This is Deborah Lowy, my sidekick. I am pointing to you, and I don't know if they can see you on the screen or not, but here we are. We have Joanne and Luke and Terry and Danielle with us tonight. We are going to be talking about notary conduct and ethics. These are things that when you take those loan signing classes, you don't learn these things. So we're going to talk about it. And I frequent notary sites on a couple other places other than here. And I keep seeing things that is not allowed in Michigan. So I want to start with, and we already covered it in one of the other classes, but there are notaries out there in other states that are allowed to, I want to like, they can fan the pages. Okay, something like this. It's all fanned. And then they can stamp across the fan to show that those documents go together. We aren't allowed to do that in Michigan. That is against the law. So all these things that we've been talking about are all law. So you can't do it. And if you aren't familiar with it, you need to find Milona, Milona. It's the Michigan Law on Notarial Acts. It is Act 238 of 2003. It has been updated a few times. But we need to go through the conduct and ethics, and then we're going to talk about a couple best practices too, because sometimes things aren't law, but it is a best practice. And when we talk about best practice, it's the kind of thing that keeps you out of court. So um, giving legal advice, don't do that. Get a lawyer, keep them in your back pocket, so that you can refer them. So the very first page of Milona does not have any notary conduct on it, but the second page, thank you for putting that in the chat, Deb. The second page is we're going to talk about official misconduct, because when you do something wrong, your E&O insurance does not cover you doing something that the law says is illegal to do. Okay, so I want to make that clear. E&O insurance covers, like, if you do something right, but you end up in court, they will defend you. And if you have done it right, but still lose in court, it will pay whatever you have to pay. But if you do something illegal, your E&O does not cover you. So ignorance of the law is no excuse. So that's why it's so important to educate yourself before you get yourself out there. Okay. So let's talk about the first thing they talk about is official misconduct, because they have a bunch of definitions at the beginning of this. So we want to cover those things first. Official misconduct means the exercise of power or the performance of a duty that is unauthorized, unlawful, abusive, negligent, reckless, or injurious. Now, they're not talking about like riding your bike in front of a little kid that's running down the street. That's not how they're talking about it. They're talking about signing a document that you know, or maybe you don't know, but you didn't do your due diligence, is not proper to be notarized. So maybe somebody brings it to you and says, I signed this earlier. Can you just sign it? I don't have my ID with me. You know who I am. Like, no, no. Yes, Deb.
So early on in my notary career, had a guy contact me and he said, I need to sign a deed, a quit claim deed. And I said, a quit claim deed. And I
Quit.
said, quit,
QUIT.
what a
Quit claim.
quit claim
That's
deed.
another
Yes.
thing.
And
Best practice. It's a T. Quit claim deed.
and I said, okay, do you have the document? Yes. I said, do you have your current valid ID? And he goes, well, the property is my brother's property. And I said, is your brother signing? He says, no, I'm signing. I need to sell this property so I can get the money I need to send my daughter to school. And I said, that's not legal. So
Right.
that is the kind of stuff that we're talking about, where you clearly know that it's wrong.
Yeah.
All right.
Right. They can't pay you enough to stay out of jail or to go to jail for them or to pay a fine or anything. So You've got to do your due diligence and make sure. Okay. Another one is charging a fee that exceeds the maximum amount authorized by law. So I'm going to say, here's what you can charge. By law, you can charge $10 for every time you sign. You can charge nothing. You can charge one, two, three, four, up to $10 maximum per your signature. And you can charge a travel fee that the people agree to prior to you going there. That's all you can charge. Okay, that's it. That's what the law allows. You cannot overcharge people because you had to get up from your desk and they interrupted your day. That is illegal. You cannot charge people because you have to drive across town and you don't want to drive across town. You can't charge people more because it's nighttime or because it's heavy traffic, nothing like that, unless they agree to it. If you say, look, I have to travel across town, it's going to take me an hour, 20 minutes to get there instead of 10. So I'm going to charge you $150. I mean, I don't know who would do it, but if they say, okay, you can collect it. I don't know how you look in the mirror. I don't know how you sleep at night, but they have to agree to it before you go. Okay. There are people out there who are going to teach you how to get just skirt around that law. Don't be that person. Don't be the person who takes advantage of people. If you came into the notary world to make a lot of money, it's not going to happen. There's a lot of money being made off of telling people that they can make a lot of money being a notary. There is even a website where they will download the paperwork from the internet, send it to you, you fill it out, and then you have to still take it. You're paying them $99 for them to say, here, go do this. Like, why? Why? Just go to the state website and do it yourself. Tangent, never mind. Record. They're saying record here. Record means information that's inscribed on a tangible medium. Tangible means you can touch it. Medium meaning it's a thing like a paper or digital copy or whatever that is stored in an electronic or other medium and is retrievable in perceivable form, as in it's not going to be, what is that word? Encrypted when you download it. Okay. Revocation means the termination of a notary public's commission to perform notarial acts. Okay, so that's what will happen at the bare minimum if you do something against the law. All right, so the notary public's appointment, the secretary may appoint as a notary public a person who complies with the requirements of this act. Except as otherwise provided in subsection 4, a notary public may reside in, move to, and perform notarial acts anywhere in this state from the date of appointment until the notary's birthday, occurring not less than 6 years and not more than 7 years after the date of his or her appointment, unless the appointment is canceled, suspended, or revoked by the secretary or operation of law. The secretary shall not appoint as a notary public a person who is serving a term of imprisonment in a state correctional facility or jail or any other state, in this state or any other state, in a federal correctional facility. So you can't be a felon and a notary. I wonder if you can be an ex-con. I think there's actually rules for that. Qualifications. You have to be at least 18 years of age. You have to be a resident of this state, or you have to maintain a principal place of business in this state. You have to be able to read and write in the English language. You cannot have been convicted of a felony, misdemeanor, or violation as described in 41. So we're going to switch to 41 here. And we're going to read that. If an individual is commissioned as a notary public in this state, is convicted of a felony or substantially corresponding violation of another state, the secretary shall automatically revoke the notary public commission of that individual on the date that the individual's felony conviction is entered. So if you are a notary and you become a felon, you no longer are a notary, but you're still a felon. There we go. If an individual commissioned as a notary in the state is convicted of 2 or more specified misdemeanors within a 12-month period while commissioned, or of 3 or more specified misdemeanors within 5 years, regardless of being commissioned, the secretary shall automatically revoke the notary public commission of that individual on the date that the secretary determines the misdemeanor of which the individual was convicted is a specified misdemeanor. As used in this subsection, specified misdemeanor means a misdemeanor that the secretary determines involves any of the following. So here we go. Check yourself here. A violation of this act. So if you knowingly do something wrong and you violate this whole Milona, any part of it, that is a misdemeanor. A violation of the public trust. Debbie, will you look up the public trust and see what they mean by that, please? An act of official misconduct, dishonesty, fraud, or deceit. That is not limited to your clients, okay? It could be writing a bad check, okay? Or using somebody else's ID. An act substantially related to the duties or responsibilities of a notary public. If an individual commissioned as a notary public in this state is sentenced to a term of imprisonment in the state correctional facility or jail in this or any other state, or in a federal correctional facility, his or her commission as a notary public is revoked automatically on the day of which he or she begins serving the sentence in the jail or correctional facility. If an individual's commission as notary public is revoked because he or she begins serving a term of imprisonment and he or she performs or attempts to perform a notarial act while imprisoned, he or she is not eligible to receive the commission as a notary public for at least 10 years after they complete their term. Did you find that, Deb? Oh, do you want? There we go.
No, I got it. Technology is not my friend tonight, people. I'm sorry.
It's okay. All right. So what is a violation? What is the public trust?
Public trust. The concept of public trust relates back to the origins of democratic government and its seminal idea that within the public lies true power in the future of society. Therefore, whatever trust citizens place in its officials must be respected.
Okay. So you are a public official, being a notary public, and if you violate public trust, you lose your commission. Okay. Thank you, Debbie. An individual found guilty of performing a notarial act after his or her commission as a notary public is revoked under this section is guilty of a felony punishable by a fine of not more than $3,000 or by imprisonment of not more than 5 years or both. So we did have two individuals who are having a trouble getting their new commission. So you don't get recommissioned and you don't get renewed commission. You have to apply for a new commission after when your commission expires. And they say to do it within 60 days prior to your commission expiring. The thing is, I know of two people who it wasn't going through. Okay. And other people have called for them and it wasn't working. I advised them to call every day and don't give up. Call every day and just be that squeaky wheel. Eventually they'll answer the phone. I did get word back, I think it was late last night, that one of them, it went through. And the problem was that it was sitting in background check. And I'm sure it was background check because for her, it was a name change and it wasn't going through. So it got pushed through. So we're happy. We got one of the two we know is through. So that's great. But you can't, in the meantime, she couldn't be a notary for like 2 or 3 months. She couldn't notarize anything because she had submitted a change and it hadn't been approved. It was in limbo. That wasn't allowed. So she couldn't make any money. Okay. An individual, regardless of whether he or she has ever been commissioned as a notary public who is convicted of a felony, is disqualified from being commissioned as a notary public for not less than 10 years after they complete their sentence for that crime, including any term of imprisonment, parole, probation, and pays all fines, costs, and assessment. As used in this section, a felony means a violation of penal law of this state, another state, or the United States, for which the offender, if convicted, may be punished by death or imprisonment by more than 1 year. It's not saying you're going to be put to death if you're a notary and you do something wrong. This is the definition of a felony. I had to find that. Debbie told me that. I was like, simmer down.
Simmer down.
I was like, hey, that's so harsh. Oh my God. I'm going to be hung. Like, we don't even have the death penalty here, but it applies to all the state. Don't do anything wrong anywhere in the United States because you're going to lose your commission. Okay. If an individual is convicted of a violation described in subsection 5, the court shall make a determination of whether he or she is a notary. If the individual is a notary, the court shall inform the secretary of the conviction. And if an individual commissioned as notary public in the state is convicted of any felony or misdemeanor in any court, he or she shall notify the secretary in writing of the conviction within 10 days after the date of commission. Okay, that was a lot. So we know that is that part of it. Did I switch the page here? I did. Section 41.
I'm kind of curious because it would seem like if you got convicted, like there should be checks and balances within the system to like send out the smoke signals so they'll know. But it sounds like it's on you, the notary, to notify the Secretary of State that now you've been convicted.
No, actually, that's not what it says.
Okay.
It says if an individual commissioned as notary public in the state is convicted of 2 or more specified misdemeanors, blah, 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 the secretary shall automatically revoke the notary public. I'm sure it's in the system. Look, if the IRS has my tax return from this year and all of a sudden my credit card companies say your credit limit has changed, you know they're talking. So I'm sure it's the same thing. Okay.
Okay.
All right. So we have the qualifications. Okay. For an applicant who does not reside in the state of Michigan, demonstrates that his or her personal place of business is located in the county in which he or she requests an appointment, and indicates that he or she is engaged in an activity in connection with that business in which he or she is likely to be required to perform notarial acts. So this is a question that's asked a lot. Can I get dual commissioned, like 2 different states? So Michigan says, if you don't live in Michigan and you want to be a notary in Michigan, it has to be connected to your job. So there are people who go, oh, well, I'm in Florida half the year. I want to be a notary down there. Michigan doesn't allow that. Michigan says if you're going to be dual commissioned, it has to be for your job. Okay, I don't know what Florida says. I don't really care. I know what it says here. And if you're doing it for your job, that's cool. If you're not, they're not going to allow it. Okay. If applicable, wait, do we have that? Okay. Has filed with the county clerk of his or her county. Where are we at in the law? We are on page 3 of the Michigan Law of Notarial Act. It's 55.271 Notary Public Qualifications. You're welcome. If applicable, has filed with the county clerk of his or her county of residence or expected appointment a surety bond and an oath under Section 13 in a format acceptable to the secretary. The requirement of filing a bond does not apply to an applicant that demonstrates in a manner acceptable to the secretary licensure as an attorney. So if you're an attorney, you don't have to have a bond, apparently. They take care of it otherwise. Hi, Joanne, what's up?
Okay, I wanted to ask, if your address is different on your bond than all the rest of your paperwork, do you need to go back and change your address on your surety bond?
You should let your insurance agent know that you moved.
Okay.
And update it for sure. And it's going to be for anything that's legal, any type of insurance that you ever have, you would want to let them know that you moved. So yeah, I would say yes. Just let them know, send them an email.
Okay.
Did you cross counties? Did you go from like Wayne to Oakland or something like that?
No, I have a different address when I got my surety bond because I needed it for an appointment, for your appointment to get your notary. But I changed my address because I used my office address instead of my home address for my surety bond. So now I want to use my actual address that I have on my EIN and my LLC papers.
Yeah, I would say everything should match. That's a best practice. Thank you, Joanne. Okay, So the last one under notary public qualifications is that the secretary shall, on a monthly basis, notify the county clerk's office of the appointment of any notaries in that county. So it is important that if you do move counties or you change your address, that you do so with the state too. Okay, filing.
So wait, question. Because you got to go to the county clerk to take the oath. So
Yep.
wouldn't the county clerk know before the Secretary of State? Or
I
it's
mean,
like they're reverse telling them.
yes, but do they talk to each other? Have you been, like, I know when I went, I am sure it was a deputy who swore me in. I doubt she went over to the clerk and said, "Hey, Leslie's a notary now." Like, it's all there, but what do they do with it? Who knows? I don't know. I'm telling you what it says here because I
I'm just
know a lot
curious,
of
like,
people
what does
haven't
that
read it.
notification look like? Is it just like it populates a database? Is it a
Ding!
spreadsheet that gets sent out?
There's a
I'm
bell
very
at the
curious.
door. We have a new notary. She said yes to the notary. Yeah, no, I have no idea. Maybe I can find that out for you
Yeah.
and then I'll let you know on a future broadcast. Okay. It's actually, now I'm going to be thinking about that. Okay. Anyway, filing an oath and bond and fee. So we've all been there, and I'm only going through this because there's some people who might want to be a notary who might watch this. So I'm going to go through it kind of fast. But everybody here is already a notary, correct? Nod your head. I know the other ones who aren't showing. I know they are. Okay. Within 90 days before filing an application for notary public appointment, a person shall file with the county clerk of his or her residence or expected appointment a property surety bond and an oath taken as prescribed by the Constitution. We do have to get that oath taken at the county clerk's office, just so that if anybody's out there watching, you do have to go there. The bond shall be in the sum of $10,000 with good and sufficient surety and by a surety licensed to do business in the state. The bond shall be conditioned upon indemnifying or reimbursing a person, financing agency, or governmental agency for monetary loss caused through the official misconduct of the notary in the performance of a notarial act. The surety bond protects the public from what you do wrong. The surety is required to indemnify or reimburse only after a judgment based on official misconduct has been entered in a court of competent jurisdiction against a notary public. The aggregate liability of the surety shall not exceed the sum of the bond. The surety on the bond may cancel the bond 60 days after the surety notifies the notary, the secretary, and the county clerk. So just like any other insurance you have, if you do something wrong and they have to pay, they might cancel you. Nice. The surety is not liable for breach of a condition occurring after the effective date of the cancellation. The county clerk shall not accept the personal assets of an applicant as security for a surety bond under this act. Here, let me just put my house up. If I do something wrong, just take my house. No. Each person who files an oath and, if applicable, a bond with a county clerk as required in subsection 1 shall pay a $10 filing fee to the county clerk. Upon receipt of the filing fee, the county clerk shall give an oath of filing and a bond, and if applicable, the bond if applicable, because if you're an attorney, you don't have to have that, to the person as prescribed by the secretary. A charter county with a population of more than 2 million may impose by ordinance a fee for the county clerk's services different than the amount prescribed by the subsection. Debbie, can you look up and see if we have any counties in Michigan that have over 2 million people in them? I'm thinking maybe Oakland might, maybe Wayne. $2 of each fee collected under this subsection shall be deposited into the Notary Education and Training Fund established in Section 17 on a schedule determined by the Secretary. I'm actually trying to figure out where that money goes, so I'll keep you all posted on that. Application format fee, use of lien or iChat certificate of appointment, electronic application payment process. An individual shall apply to the secretary for appointment as a notary public in a format prescribed by the secretary. Unless the application is submitted electronically under subsection 5, an application for appointment as a notary public must include the handwritten signature of the applicant. An application must include all of the following: your name, your residence address, your business address, date of birth, residence, business and telephone numbers, and electronic email or your email address. Did you find it, Deb?
Yet none of them do. Wayne County's got 1.7 and Oakland's got 1.2 million.
Awesome. So we don't really, that's there and doesn't even matter. Okay. The applicant's driver's license or state personal identification card number, a validated copy of the filing of the bond, if applicable, and an oath certificate received from the county clerk. If applicable, a statement showing whether the applicant has previously applied for an appointment as notary public in this or any other state, the result of the application, and whether the applicant has ever been a holder of a notary public appointment that was revoked, suspended, canceled, or in this state or any other state. A statement describing the date and circumstances of any felony or misdemeanor conviction of the application during the preceding 10 years. A declaration that the applicant is a citizen of the United States, or if not a citizen of the United States, proof of the applicant's legal presence in this country. An affirmation by the applicant that the application is correct, that the applicant has read this act, which apparently they don't follow through on that. Hey, Luke, have you read this, Milona, all the way through? Nope. See? That's what I'm saying. This is the thing. They don't give us proper training, do they? On page 5 of this, it literally says, before a notary public performs any notarial act, the notary public shall obtain and read a copy of all the current statutes of this state that regulate notarial acts. This whole thing. It's, hold on, how many pages is it?
Like 15.
Pages. 15 pages you're supposed to read before you use your stamp. You might want to do that. I mean, we're going through it here, but you might want to do that for yourself too. Yeah. I don't mean to call you out. I just know that you're new. And so I just kind of try to help the new people. But this actually says that you've made a statement saying that you did. And I wasn't asked if I did. Were you asked?
Either. Nope.
Joanne, were you asked?
I don't think I even knew about my loaner when I took my oath.
No, I don't think so either. But here we are saying that that's what they're saying when we do it. An affirmation by the applicant that the application is correct. Cool. I know that's my name, address, phone number, right? That the applicant has read this act. They didn't ask me that. And that the applicant will perform his or her notarial acts faithfully. That they did ask.
Yep.
You know, they asked that we're going to follow them.
Yep.
Okay. So great job, state of Michigan. Okay. Any other information required by the secretary? Cool. That leaves it wide open. That was its own little line there. An application processing a fee of $10 must accompany an application or be paid electronically under subsection 5. The secretary shall deposit $1 of each fee collected under this subsection into the Notary Education and Training Fund established in section 17 on a schedule determined by the secretary. Still would love to know where all that money is going. Where's the other $9 going? And where's the other $8 going from the other thing? We don't know. When he or she receives an application and the prescribed processing fee, the secretary may inquire as to the qualifications of the applicant and shall determine whether the applicant meets the qualifications for notary appointment as a notary public under this act. How? To assist in deciding whether the applicant is qualified, the secretary may use law enforcement information network as provided in the Policy Council Act, or the Internet Criminal History on iChat, and maintained by the state police to check the criminal background of the applicant. Okay. And I know they do that now because of what I heard yesterday, that when her name change went through, it was stuck in background check. So it's pretty automated and gets flagged, I guess, if it's pulled. After approval of an application for appointment as a notary public, the secretary shall mail directly to the applicant the certificate of the appointment as a notary public. How many people here got theirs mailed to them?
I didn't. It was email. Well, that's mail. Email. They didn't specify what type of mail. Mail.
It does say mail. It does not say mail electronically. It does not say email. It says mail. Directly to the applicant. I didn't. Are they breaking the law? I digress. Each certificate of appointment shall identify the individual as a notary public of the state and shall specify the term and county of his or her commission. The secretary may develop and implement an electronic application and payment process for individuals who are seeking appointment as notary public. That recently happened, like within a month ago, that happened. Except as provided in this section, all of the requirements of this section apply to an application or payment made using the electronic process. Okay, that's cool. That did just happen. Apparently, they've been working on it for a while. looks like 2019, they put that into effect. So that's cool. Please note that even though you are commissioned in a county, you are able to notarize in any county in Michigan, but you have to put on your stamp what county your feet are planted in when you are notarizing. You cannot notarize outside the state of Michigan unless you are doing business outside the state of Michigan and are commissioned in that other state. So as long as you're here, feet planted in Michigan, you can notarize. Some people do ask if I'm a RON or electronic notary, can I notarize like when I'm on vacation if it's for somebody in Michigan? And no, that's not how that works. Your feet have to be in the state of Michigan, on soil in the state of Michigan, in order to legally perform a notarial act, whether it's electronic or pen and paper. Okay.
But the client can be anywhere.
If client can be anywhere. They can be in Europe, China. Although it's not fun doing those China ones because you're up in the middle of the night. That's tiring. 55.279, reappointment, licensed attorney as a notary public, cause for cancellation of appointment. The secretary shall not automatically reappoint a notary public. That's what I was talking about before, where we have to apply for a new commission when ours is up. So 60 days prior, go do all the stuff, get your commission again. A person desiring another notary public appointment may apply to the secretary in a format prescribed by the secretary for an original appointment as notary public. The application may be submitted not more than 60 days before the expiration of his or her current notary public commission. Best practice, that 60-day. Don't wait till 3 weeks before. Don't wait until the day before. You'll be without a commission. So it doesn't, if they recommission you, if they like put it through right away, that's golden. But you don't want to have to be waiting beyond it. In most of the cases, it goes very smoothly, but there are times when it doesn't. So you need to be prepared for the worst because you don't want to, if you have a business as a mobile notary and you are out there doing work and it's coming in, you do not want to have to tell somebody, sorry, I'm not a notary for the next, 6 weeks or something like that. So you want to make sure that you are giving yourself an opportunity to be able to get that commission going and continuing without a lapse. Okay. I do recommend that you have another notary available so that you can say, I'm sick, I'm going to send somebody else though, so you don't actually lose the momentum that your business has. Okay. But business stuff is totally separate. If you want to grow your business as a notary, contact me on the side. I don't do that for free, but I can help you. And mine is going very well, just so you know. And I did just do my taxes, and I want to let you know that I doubled my income in 2022 from 2021. So I know it can happen. It's great. Okay. Reappointment, licensed. Okay. Secretary shall not reappoint a person desiring, where am I? In the case of a licensed attorney, they don't have to do what they do. Not only does the state remind the attorneys that their commission is expiring, they don't have to get the surety bond. So whatever. The secretary shall automatically cancel the notary public commission of any person who makes, draws, utters, or delivers any check, draft, or order for the payment of processing fee under this act that is not honored by the bank, financial institution, or other depository expected to pay the check, draft, order. So don't bounce your check. Make sure you don't get anywhere near.
That's harsh. That's harsh.
It is.
I think that's harsh. Man.
Okay. I don't have this part as a best practice or ethics things per se, but it's something that comes up. So I want to go through it. Because it just came up the other day, like twice in like 2 days back to back. Corrected notary public commission. Okay. So a notary public shall immediately apply to the secretary in a format prescribed by the secretary for corrected notary public commission upon the occurrence of any of the following circumstances. A change in the notary public's name. And that was one of the people who was stuck in the background check. She changed her name. She did everything she was supposed to do. Once you submit that change form, you aren't supposed to do anything because you don't know which way you're supposed to sign it, right? But you also can't order your stamp until you get your new commission. So she was stuck in limbo. Like, that was sad. So change in your name, a change in your address, or your business address. So Joanne, that goes back to what you asked before. The issuance by the secretary of a notary public commission that contains an error in the person's name, and that's what we ran into twice. The birth date, the county, other pertinent information if the error was made on the notary public's application and was used by the secretary to appoint the person as a notary public. So if you filled it out wrong and they issued it wrong, you've got to correct it before you start doing it. The notary public shall immediately notify both the secretary and the county clerk of his or her appointment in a format prescribed by the secretary upon any change in the factual information stated in their application for appointment. So that's what they just said was the factual information. I can't think of anything else as factual. But I will say this, and this actually explains that whole Ron thing that we had going on. So I'm taking an aside here because squirrels are my thing tonight. When you are a remote online notary, first of all, you can't do remote online notarizations without being commissioned that way. So it's like get your commission, then apply for Ron commission. Okay. Two separate things. If you look it up on the state website, you're going to see it in two separate ways. You have to be associated with a platform. So there a whole different video that we did last week was Ron week. Debbie went through that whole thing, how you can make that happen. So watch for that on YouTube, or I think she put it up there today. Thank you so much, Deb. Yep. But then it right here, it says you have to immediately notify both the secretary and the county clerk. They talk to each other. We don't have to do that. Upon any change in the factual information stated in the notary public's application for appointment. So this is where that nitty gritty comes in. If you add a Ron platform, factually, it has to list all of the platforms that you are with. So in my case, the first platform that I onboarded with was Cyberize It. 3 weeks later, I added, I think, Notarize or something. It wasn't notarized because it wasn't in Michigan yet, but I added another platform. Every time you add a platform, the list that you have on your change form has to be complete. You can't like just add another one there. You have to put the complete list every time, and you have to add proof of your association with that platform every time. Because here's what it says. 55.281 corrected notary public commission, and it is number 2. A notary public shall immediately notify both the secretary and the county clerk of his or her appointment in a format prescribed by the secretary upon any change in the factual information stated in the notary public's application. That change form has to be complete with all of your changes, with everything about your commission. So you're adding a platform, you have to list the platform you're already with and the new platform. And it might be 7 to 10. Debbie, how many do you have on yours?
9, I think.
There you go. So it's a lot. I have 2 on mine. No deal. I mean, it's fine. If you're going to do it, you've got to do it fully. That's where, like, we've been looking for this. Why do we have to do this? But that is why, and it's right there. Now it makes sense. I mean, sometimes you don't realize these things till you're going through it with a fine-tooth comb. I didn't have that. The first time I read that, it didn't connect those 2 dots. Now the dots are connected. So that's cool.
The dots just connected for me. So just so you know, like I didn't get it before.
Just now.
Just now.
And I'll tell you, Debbie and I have gone through this Milona at least 6 times together. Those dots just connected right now. So anybody out there feeling bad about it, don't worry about it. I mean,
it's legal speak. Like who grew up speaking legal speak? I think I fell asleep the first 3 times I was trying to read this thing by myself. Like it is dull.
It is for real. So we try to add a little bit of lightheartedness. If you're out there and you're watching this and you're like, that girl's crazy, you're welcome. Okay. Secretary shall notify the county clerk of it. There's got to be like some system that they just shove it over there and shove it back. I can't imagine they're like, hey, Jay, did you know?
I know, right?
I had the updated list, boss. Here it is. And you're like, okay, don't really care unless I mean, does it matter? They're coming, I don't know, whatever. Secretary shall notify the county clerk of the applicant's appointment when a corrected commission is issued by the secretary. It probably just gets uploaded and now they're there. But I'll find out. I'll see what I can find out. If a notary public's certificate of appointment becomes lost, mutilated, or illegible, the notary public shall promptly apply to the secretary for an issuance of a duplicate certificate. The application may be made on a form prescribed by the secretary and be accompanied by a processing fee of $10. $1 of each processing fee shall go to the Notary Education and Training Fund. What do they do? Educate you to not mutilate your document? Actually, this is where the email thing comes in pretty handy. I can just go back there, pull it up, and print a new one.
That's exactly what I was going to say. Like they email it to you. You print it out and you throw it in a frame and put it on your wall.
So for those of you who are getting it in the mail, scan it and save a copy on your computer so you can just reprint it if you need to. And what I did, okay, so one of the girls that I mentored last week shows up with this binder with all her proof, like all of her NNA stuff. And I'm like, you will never be asked for that information. She's like, the state says I have to keep my card with me. I said, yes, you are supposed to keep your commission card with you. So they give you a big certificate and then they give you that little card. I laminated mine and it's on a little clip and it's in my bag. And I have literally never been asked for it. Never. I have been asked for my driver's license. And because I had asked for theirs, that's why they wanted mine. I happily pulled it out and I let her ID me. It made her feel better. I was in her home with her stuff, with her paperwork that has her information on it. I was very happy to say, this is who I am. If you need a copy of it, go ahead. She didn't need a copy. She just wanted to make sure that who that person was sitting in front of her was the person who is carrying the ID for that. And she felt better after that. I had no issue with it. I do hear some people who are like, I'm not showing my ID. You know, if you're going to be combative, you're in the wrong business. I'm just going to say that. Joanne, question.
Can you show your notary card instead of showing your ID?
I could have. I totally forgot it was in my bag, but I mean, I had the stamp. She knew, like whatever. I would have if she had asked.
Okay, I'm just saying if you wanted to provide a different identification besides your driver's license.
So my notary ID, my commission card, doesn't have my picture on it. That would not have satisfied her. She wanted to know that I was the person who I said I was. She had my business card, my pictures on it that can get printed by anybody. The state ID is what she wanted. I saw hers. She wanted to see mine. I was okay with that. I really don't have any issue with that at all. And what is she going to do with it? She wasn't going to like take a copy of it and go. She didn't. As a matter of fact, when I said, if you want to make a copy of it, she's like, no, I'm fine. Like she kind of felt embarrassed after that, but it was only one time and it was one person. It's very rare. I've done 1,800 notarizations, actually met with 1,800 people in 2022. And all those 1,800 people, one person asked. So it's not going to be very often. No worries. All right. And then we get to the part where it says you're supposed to read this whole thing before you become a notary. For all you people out there. And I'm sure Debbie's going to link this in the on YouTube. Or are you going to put it down and like in the bottom?
Yeah.
The people who
my Lona
in front. Yeah.
Yep.
The people in front. Okay. Okay, let's move on here. We get to skip a couple pages.
All right. Just tell me where you're at next. Because I'm following along on my other screen.
Okay. I don't know if there's any more because I'm trying to. Oh no, I know there's another page. Oh, here we go. Notary public prohibited conduct.
Hold on. What page are you on?
11.
Okay, hold on.
I have to wait for Debbie. Please wait.
There's
right. There's nothing on the screen showing it, but I let me wait for Debbie.
All right, go ahead.
Did you have some? Can you like edit some? Can you edit some Jeopardy music in there? So
I you know what? I might just do that.
Okay. Section 55.291 Notary Public Prohibited Conduct, page 11, if you're following along. A notary public shall not certify or notarize a record that is either of the following. And then they list like 6 things. So it should be any of the following. Who taught them grammar? Wasn't me. An original. We cannot say this is an original. So just for clarification, the other day when I met with a few notaries, there are some true copy statements that you can buy on the internet. It's a paper. Some states allow you to say, yes, this is a true copy. Michigan does not. Michigan says that the client needs to make a copy of whatever it is that they need made, which would be like driver's license, birth certificate, passport, and they need a true copy statement. They have to write that true copy. This is a true copy of my birth certificate, and they have to sign it. You are then notarizing their signature on that true copy statement. You are not certifying that this is a true copy. You are not allowed to make that copy. You are notarizing their signature saying it's a true copy. That is how we get around that. We notarize signatures, not documents. Signatures, not documents. That's going to be a chant. I'm going to make up a cheer and we're all going to learn it. And the whole state's going to be like, signatures, not documents. Anyway, so we cannot notarize any records. Okay. We notarize signatures, not documents. So no originals, no true copies of another record. Again, their signature saying it is, but not you doing it. A notary public shall not do any of the following. They shall not perform a notarial act upon any record that he or she has executed. We cannot create our own documents and then notarize them. Attorneys might be able to, but we can't. Terry says, my coworker has a form that says, if his ex-wife goes over, whoa, hold on, I love gossip here. My coworker has a form that says if his ex-wife goes over her leasing miles, he will pay the bill for it. The dealership told him he had to have it notarized. If no notarial block, he would pick the right one he wants. Am I right? Yes. He would pick whether it's an acknowledgement or a jurat. So you would say, I can notarize your signature on this. I am not notarizing the document. Do you want this to be an acknowledgement or a jurat? An acknowledgement says, yes, you signed this. A jurat says, what you're signing is true. Which would you like? Shut up. It is not up to you to help them decide. You can re-describe it if you'd like. They're going to say, I don't know, which one would you do? Or, I don't know, just pick one. No, you can't, because that's practicing law. So, yes, Terry, you did that very well. Thank you. That is such a funny document. Because he got a car for his ex-wife. You got to wonder about some people's relationships. Okay. They cannot notarize their own signature. That means if they know the note, if you're acting as a witness on the document and your signature is, or the witnesses are listed in the notarial block, you can't notarize that. So again, one prior, I think we just went over some notarial blocks in yesterday or Monday's, I think Monday's Zoom.
Mondays. Yep.
Is that uploaded yet?
Yeah. Monday, it dropped at 6:00 this evening, so it's out there.
Okay, so that would be the February 6th video. So watch that one. You cannot take your own deposition or affidavit. Like, how would you even do that? Go stand in front of the mirror, give yourself an oath. That's so funny. I mean, sometimes you do have to describe things to people. We do have to break it down to stupid. Okay, we're fine. A notary public shall not claim to have powers, qualifications, rights, or privileges that the office of the notary doesn't provide, including the power to counsel on immigration matters. Okay. Great. I don't know anything about immigration, so I wouldn't do that, but for some reason they listed that on its own, so okay. A notary public shall not, in any document, advertisement, stationery, letterhead, business card, or other comparable written material describing the role of a notary public, literally translate from English into another language terms or titles included, but not limited to notary public, notary, licensed, attorney, lawyer, or any other terms that implies a person is an attorney. And that is because notario publico in Mexico, I don't know if Spain too, means attorney. So we can only use the term notary public to describe ourselves, no matter what language you speak other than English. It's not allowed. You are always just a notary public.
I want to go back like 2 statements before when you talked about the immigration, because that is all over the NNA, like take this class and learn how to do immigration paperwork. So in other states, they can do immigration paperwork. Okay. So just so everybody and everybody out there watching the video right now just know in Michigan, we're not allowed to work on or manage or notarize immigration documents.
That is so good to know. Thank you so much. We live so close to the border that I'm sure there's people who are, if they're contemplating it, and if you're doing it, I'm sorry, you just lost your stream of income there. Okay, a notary. Thank you for that, Debbie. A notary public who's not a licensed attorney and who advertises notarial service in a language other than English shall include in the document advertisement, stationery, letterhead, business card, or other comparable written materials, the following prominently displayed in the same language. I am not an attorney. I have no authority to give advice on immigration or legal matters. So if you're advertising in another language, you have to have that on there, okay? Prohibited conduct, fees for notarial acts as specified by the statute, which is how much? Go ahead, Deb.
Anybody? Oh, $10 is the max.
Right. Plus a nominal travel fee that's agreed upon before you leave. Here's my thing. If I get called somewhere that I have to charge $100 travel fee, I'm calling a notary who's close.
Yep.
Like, I'm not going to pass by 19 notaries just so I can make a buck. Like, let somebody else do it. That's why we refer to everybody. I have like, I don't know, 90 or 100 or 200 notaries in my phone. Like, I'm not going places it's not feasible. Okay. A notary public shall not perform any notarial act in connection with a transaction if the notary public has a conflict of interest. As used in this subsection, conflict of interest means either or both of the following. The notary public has a direct financial or beneficial interest other than the notary public fee in the transaction. Now, what are some examples of that? Debbie, do you know?
Hold on, let me let Joanne back in.
I'm
sorry. I was focused on, you skipped number.
I skipped one?
6. You skipped 6.
Okay,
you
we'll
said
go back
it already. It was about notarial publico. So let me look at it.
Yeah.
In connection with transaction.
I kind of put it in with the other one. Okay. So what kind of document would we have that we would have a financial or beneficial interest in?
Like POA a will, or a will,
trust, a power of attorney,
bill of sale, or
Yep.
It could be a lot of things. It could be adoption or custody paperwork.
Yep. All of those things.
401k.
Yeah, you can't do any of your own stuff. Okay, you can't do it for your family either. We're going to get into that right now. If the notary public is named individually as grantor, grantee, mortgagor, mortgagee, so all these people who are like, I'm buying a house, can I notarize my own paperwork? That's a no. Trustee, trustor, beneficiary, vendor, vendee, lessor, lessee, or as a party in some other capacity to the transaction. Okay. A notary public shall not perform a notarial act for a spouse, lineal ancestor, lineal descendant, or sibling, including in-laws, steps, or half relatives. That means not your children, not your grandchildren, not your sister-in-law, not your brother-in-law, and that means whether it's your brother's wife or your sister's husband, but also your husband's siblings and their spouses. Those are no's. But their kids, you can. You shouldn't. Best practice says no. Best practice says just walk away from it. You don't need, if you need that $10 that badly, call me. I'll help you.
Or call another notary.
When you make friends with other notaries, sometimes they don't charge you. I'm just saying, you do it for each other. It's not a problem. Okay, a notary public who is a stockholder, director, officer, or employee of a bank or other corporation may take the acknowledgement of a party to a record executed to or by the corporation, or to administer an oath to any other stockholder, officer. This is all, you can't do this. Officers, director, employee, or agent of the corporation. A notary public shall not take the acknowledgement of a record by or to a bank or other corporation to which he's a stockholder, director, officer, employer under the circumstances where the notary public is named as a party to the record, either individually or as a representative of the bank or other corporation, and if the notary public is individually party to the record. So, like, if I worked at a bank and my uncle came in and opened an account or got a home equity line of credit and it needed to be notarized, most people who work at the bank are notaries, but those notaries cannot work on that, cannot notarize their uncle's signature at the bank because that's not allowed. Okay. For purposes of subsection 7, which, as a reminder, shall not perform any notarial act in connection with transaction if the notary public has a conflict of interest, and all of those things that we just said. The notary public has no direct financial or beneficial interest in the transaction where a notary public acts in the capacity of agent, employer, insurer, attorney, escrow, or lender for a person having direct financial or beneficial interest in the transaction. Stay away from family, stay away from anything that's going to make it where you could do it.
Amen, sister.
Oh, no.
Keep it simple. It's too complicated.
Again, I'm going to say it again. You're not going to get rich being a notary. I don't care who had told you you're going to make $100,000 a year doing loan signing. That's not happening anymore. We are now like evening out. And honestly, loan interest rates 8 years ago were in the 11s and 12s. They were double digits. So people mad about 7, they never bought a house before because people now are still happy at 7%. But the boom, when this whole you can make $100,000 a year started, at that point you could. Do I see that ever happening again? No. You can probably live comfortably on it, but you are not going to make $100,000 a year being a notary. And you're not going to make $100,000 a year being a new notary going into loan signing. There are people who are still making that, but they have direct relationships with title companies, and they do all of their closings, and they are busy all day, every day. But they're not going to say, oh, let me stop using this person who's done excellent for us for the last 6 years, and let me call you Mr. New Notary, and you come in and do it. Nah, you have to make your own business out of being a mobile notary. You have to go out there. You have to do the work. I am more than happy to teach you how to do that and teach you the method I've used that will work. But you aren't going to make $100,000 a year. I do not make $100,000 a year. I make a nice income, but it's not $100,000. And it's not through loan
and you
signing.
hustle hard. Leslie hustles hard. Yeah.
I hustle. Everybody knows I am a notary. And that's the one thing you need to make sure. If you want to be a notary, do not let one person in your life not know that you're a notary public, because you will be disappointed when you get home one day and there's a mobile notary car in the driveway next door, and you go, why didn't they just call me? And you go, well, I guess I didn't tell them that. Make sure your neighbors know. Okay. Failure to respond if the Secretary of State requests your presence or information. Here we go. Upon receiving a written or electronic request from the Secretary, a notary public shall do all of the following as applicable. Furnish the Secretary with a copy of the notary public's records that relate to the request. Within 15 days after receiving the request, respond to the Secretary with information that relates to the official acts performed by the notary public. Permit the Secretary to inspect his or her notary public records, contracts, or other information that pertains to the official acts of a notary public record if those records, contracts, or other information is maintained by the notary public. And the reason they say if is because it is not required in Michigan to keep a journal. However, it is a best practice to keep a journal because you may get called in, and if you can't remember, that is not an excuse. So if you notarize 7 times a year, you're probably going to remember 6 out of the 7. But if you are notarizing a power of attorney for a 30-something-year-old who travels a lot and just wants to make sure things are in order, and something happens and that power of attorney is contested 15 years later, they're going to call you into court. You're going to have to go. You're going to have to take your witnesses with you. So you're going to want to know who those witnesses are. And you're going to have to take your journal in and say yes. Or you're going to have to go in there and go, I think so. Yep, that looks like my signature.
So Leslie, we're at 8:07, so I just want to give you a time check. I don't know how much more we've got.
We actually are going to have to continue this because we do have a lot more best practices. Why don't we stop now? And then we will pick this up again next. Do you want to do it?